When I refreshed her recollection, I wasn't using...
I know you weren't. That's what makes it even worse. You decided to use an electronic document that you know was not 100% accurate. It's not going to be trial by ambush, not in this courtroom or not in this state. Yesterday, Caitlin Caneiro was on the stand, and during the course of her testimony, a few things came out, gave the court some concerns that there was some objections that were made. It starts off with defense counsel, specifically with respect to Jennifer's phone, was her phone ringing? Witness says, yes, it rang normally,
and then went to voicemail.
What was the approximate time frame that you were calling these phones that morning?
I would say from 9:30ish to 12.
That's approximate.
Yeah.
And to your recollection, did Jennifer's phone ring?
Yes.
Were you also sending text messages that morning?
Yeah, I texted my Uncle Keith and I texted my Aunt Jen.
Do you remember the time that you sent your Aunt Jen a text message?
No.
No. Would seeing a copy of the text message with the timestamp help refresh your recollection?
Yes.
I'm not searching with what's been marked as D154. I'm just going to direct your attention and the specific text with the okay. Does that help refresh your recollection of what time you sent the text message to your Aunt Jennifer?
Yes.
And what time was that?
10:26 in the morning.
Okay. Now, what kind of phone does your Aunt Jennifer? What kind of phone did your Aunt Jennifer have?
She had an iPhone.
And do you still have that text message in your phone today?
Yes.
And did you look at that text message recently in the past day or two?
Yes.
Now, prior to the last day or two, when was the last time you looked at that text message?
The day I sent it, November 20th, 2018.
So you haven't looked at the message since?
No.
When you looked at it in the last day or two, what, if anything, did you notice about that text message or iMessage? Is it a text message or an iMessage?
It's an iMessage and it changed from delivered to read.
Okay. So do you have any idea when that would have changed?
No, I didn't look at it for 7 years.
The fact that it now says read, did that stand out to you?
Yeah, because who read it?
I wasn't allowed to read it. At the original moment in time, prosecutor did not object, however, did object last night as a result of not just this colloquy back and forth, but the next colloquy that goes on the record, which deals with Jesse's iPad. Question, again, same witness, Caitlin Caneiro. You mentioned earlier Jesse's iPad. Answer, yes. Question, let me ask you this first. Did anyone in Jennifer, Keith, in your family share
Their locations with you?
Jesse.
And was that tied to his iPad?
Yes.
Okay. At some point, did you check the location of that iPad?
Yeah, in February of 2019.
Okay, so this is a couple months later.
Yeah.
And where was the when you checked the location, what was the location?
I'm going to object to the hearsay of this.
Can I see everyone, please? And that was the first time that the defense put the state on notice of that information. But unfortunately, due to the fact that this information was sprung on everybody, including the court, concerned about the actual two items of evidence, both being what was testified to and would be stored within the witness's phone. The text message was read, that the screenshot was provided to her the day before, and that she decided not to use it due to its late hour, and decided not to turn it over.
When you are in possession of a document that you decide not to turn over because you weren't going to use, it doesn't mean that it's not a discovery violation. They did use it They didn't use the physical document, but they used the information in there. It's clear exactly what we have here. There's no question. It's clearly inadmissible. It's provided after she said something on a witness stand. Worry about the credibility of what's been provided, how it was provided, how it became read. I have no idea, nor am I ever going to be able to know.
I want to talk about the issue of these locations from February 2019. The electronic location that she looked at from 2019, is that stored in her phone as of today?
Not that I know of. She's just relaying what she saw back in February of 2000.
That's not what I'm asking you. I'm asking you whether, obviously, you're having a conversation with her as it relates to the other text message, and there, she's like, I have a screenshot. I can't sit here and not think that somebody who's preparing a witness in a case like this wouldn't ask a question. Do you have anything in your phone that says that the location comes back to Corey's house in February 2019? Are you saying that you never tried to see if that information's electronically stored in her phone?
That's exactly what I'm saying. I didn't ask that question because she just mentioned that when back in 2019 she looked at it and saw that it said that it was at Corey's house. And because I was under the impression that they obviously had the iPad at some point but never seized it or searched it the same way that they did to Sophia's phone. And just so that the record is clear, I also want to note the text message that she sent to Jennifer, the state did a cell phone extraction. They have her cell phone extraction. When I refreshed her recollection, I wasn't using...
I know you weren't. That's what makes it even worse. You decided to use an electronic document that you know was not 100% accurate, because the document that was 100% accurate, to refresh her recollection, would have been what you had in your possession, which was the screenshot, which included underneath the word red, which is what you supplied in your exhibit. So you had something, again, in your possession that you consciously decided not to turn over. And then when you're deciding to refresh somebody's recollection, you decided to use a document that, okay, this is in discovery, so I'll use this, but then I'll ask questions and get a verbal response as to the other information that's electronically stored in the phone. That's not appropriate. It's not in any way, shape, or form. The other part of this is that you're saying in your footnote on page 2 that defense counsel further recalls the witness mentioning, so I guess this is during a conversation that you've had with her, that she confronted Corey about it, either text or phone call. Do those exist?
I don't know, Judge. I'm being in candor to everyone. I'm just relaying the context of the conversation and what was told to me. That's all. The court is clearly being accusatory toward the defense. The court is using words such as conscientious or conscious and deliberate and intentional.
I'm using it because it's true. I'm using it because it's true, Ms. Maslone. So don't say that I'm using these words for any other reason, because you did this. I didn't do it. I've given you the opportunity to ask questions and do whatever you need. And the reality is, you can roll your eyes for the record as you just did, but the reality is simply this. You were given the opportunity under these circumstances to turn over electronically stored information, and you didn't do it.
If that's the court's finding, then that's the court's finding, Judge. It doesn't seem to me that there's anything that I can say to further my position that this was not a discovery violation, nor was it an intentional discovery violation. So if the court finds otherwise, and the court clearly has, then there's nothing further that I can say.
The court summarized earlier an oral argument, but did not render a decision on the admissibility of the evidence when it was brought up at sidebar. Instead, the court expressed concern that the information, having not been previously disclosed to the state, potentially constituted a discovery violation. The court directed both parties to submit written memorandum. The court will render its decision now. Significantly, Knight uses the phrase, quote, potentially in defense counsel's possession, rather than actually in defense counsel's physical possession. In this case, we know that defense counsel physically had possession of a screenshot of a communication between Caitlin Caneiro and Jennifer Caneiro, where the document specifically shows that at some point in time, the text message was read. That item was never turned over to the state at any point in time until well after the testimony. Defense counsel actually received that screenshot on February 8th, 2026, according to defense counsel. Defense counsel had that screenshot in her possession when Katie testified on February 9th, 2026. Thus, defense counsel had actual physical possession of the electronic file. The fact that defense counsel chose not to introduce the screenshot as an exhibit at trial does not change the discovery obligation. Defense counsel's strategic decision about how to use the evidence, whether to present it through testimony describing it or through introduction of the exhibit itself, does not eliminate the requirement to disclose it to the state. Therefore, this court finds the defendant violated its discovery rule obligations. So I can't find under these circumstances that Corey taking items from the house is relevant. I find that under 403 that it actually would be a confusing issue for the jury because the probative value is significantly outweighed by the prejudicial effect of trying to understand first, was it Corey that actually took it out of the house? Was it somebody else that took it out of the house and gave it to Corey at some point in time? Was it, who knows? The answer is that no one knows that. There's no testimony to that. There's no connection that has been shown, at least at this point in time. So the fact that the allegation is that Corey took items out of that house is not something that this court finds that would overcome a 403 analysis. The second issue is one that's something that's more in line with what I can understand. The second issue deals with a failure to investigate because the police did not seize and search the iPad while they did seize and search Sophia's phone. As it relates to what the investigation revealed and what it may not have, what they did and what they didn't do, that is relevant overall in this particular case. The issue in this case is whether there was other evidence in this case that would point to a different individual other than Paul Caneiro, and the investigation and looking into other areas such as the iPad, I do find to be relevant. I do not find under 403 that its prejudicial effect would be outweighed by the probative value. So I am going to, for purposes of this testimony, I will allow the fact that the iPad was taken out of the home. However, the testimony as it relates to the GPS location is something that I'm going to strike from the record.